Versus Synquest Furlough.
Mhm.
This is Thomas Court here in Centerville.
Yes.
Miss Furlow has 6 active warrants for her arrest, and you know it. And I'm not very happy about it. I've talked to you about this before, and I know you've got a lot of kids and you need to make arrangements. But there's 5 open warrants for your arrest for multiple things.
Sorry.
And you and I have discussed this previously.
Yeah, we did. And I don't lie to you or anything. I'm gonna tell the honest to God truth. When I called and she told me that some of them was only one of them was a no bond, I asked her what was that. She said that all the rest of them was like $100 fines or whatever. But she did say the one with no bond was an aggravated assault, and I was kind of took back by that because the stuff that I've been going through it over here, it's been really, really bad, but it's only been with the male neighbors. So I have everything to show you. I'm not gonna lie to you about anything. If I would have knew that somebody pressed charges or anything, I would have came right then and there. I got too many kids to be running from the police. That's not my interest. So all these warrants and stuff like that. Last time we seen each other was October 31st the next day after Halloween when my neighbor was harassing me and I went to jail. So
here. All right. Well, the first one is from April. Which case are you here on, sir?
He has a hearing at 10 o'clock.
Okay. All right. Is no insurance, leaving the scene of an accident, open intoxicants, and driving with a suspended license from April of 24. That warrant's been out for a year. Oops. Just a minute. I'm just telling you what they are.
Okay.
The next one is a retail fraud that is from December 2nd of 24. The next one is no insurance from May of 24. 9. Driving suspended from May of 24. Darn it. And domestic violence and assault and battery from February of 24. They should have arrested you when they talked to you on that assault case, but
Middleton, not to cut you off, I'm so sorry, but I got before that case, I'm being accused of that case. The only reason I didn't prosecute or anything back because the officer called me and the person who I was helping out wanted to get her phone out of my house, and my mom even came. I have witnesses.
Don't tell me any more about it, Miss Furlow.
Okay.
Until get a lawyer to help you with this.
And I do have I have a lawyer right now, legal aid for this stuff that I'm going through. But that me putting my hands on nobody, it never was. So I want to fight that to the full potential. And the Centerville police know that.
All right. Well, let's talk about this landlord-tenant case.
Okay.
The manager is here, and Corey Grand Maison is here from Swistak Levine Law Firm that represents this complex. Good morning.
Good morning, Your Honor.
Before you logged in, I was discussing the fact with the defendant, she has several open criminal warrants. She's aware of that, and she intends to come in Monday and deal with those matters. This time, we're dealing with the landlord-tenant case. This is filed as a termination of tenancy action. And 2 We'll discuss that. Notice to quit was served on the defendant in February to move by March 6th. As a defendant in a termination of tenancy action, Ms. Furlow, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have a right to a trial by a jury or by the court. If you wish to have a jury trial, you have to advise the court here today, or you have to pay the $50 jury demand fee and file a written jury demand within 5 days. You have a right to have the case heard here in St. Joseph County where the property is located. If you can reach an agreement with the landlord, we could file potentially a conditional order of dismissal. And if the matter could be resolved at mediation and both parties are interested, the court can refer that matter to mediation. So let me make a note here. That's all who's here.
I already have a attorney right now with legal aid.
All right, we'll discuss that. And
Okay.
Jeshua, you're the manager at this complex?
Yes, sir, I am.
I met you that day that little dog bit me in the foot.
Yes, sir, you did. They're no longer in the park.
I like to know my surroundings, Mr. Cramazon, and I walked over in the park one sunny September afternoon during lunch just to see how things were going, and they've got things situated pretty well. And one of the tenants' little dogs showed up in the door, and the dogs ran out and bit me in the foot. And she was right there when it happened, but I survived it. All right. Also, we've got Kyle Evans.
He's my boss.
All right. And you told me that day that the lady was going to be moving out.
Yes, sir.
And apparently that happened. All right. Well, this is a termination of tenancy. And I don't know whether this is a subsidized lease. The notice to quit was February 25th. The defendant did not move. It looks to me like the lease is up. Ms. Furlow, you have been in contact with legal aid?
Yeah, I talked to Libby. She said she wasn't going to be able to come to the hearing today, but she'll get right back in contact with me. I did my intake and everything, and I do want to take it to trial because I have all the accuracy that I need. I want to take it to trial.
Well, let's talk about this. They want you to move.
Yeah.
Your lease is up. They gave you a month's notice to move, and you didn't move, so they filed this action.
I signed my lease in October, so my lease is up already.
All right, well, let me look. Maybe it isn't up yet.
It's not.
All right, well, then there has to be some.
Year.
I can't read it. The print's so small.
Yeah, it's very small.
Mr. Grand Maison, what's the date of the lease?
Allow me to look, Your Honor.
They printed it with four pages on a page.
Yes, and
I need a magnifying glass to read it.
Yes,
yeah, literally.
I tell my staff that the cost savings on that is not worth the hassle. Let me look at the signature pages here. The lease was signed on September the 26th of 24.
So it was a year lease, and then after that, it became month to month.
Month to month.
So we're not till September of 25 yet.
No.
Correct. Yeah, the termination is based upon the police report and the violence. It's for a violation of the community rules and the lease provisions regarding behavior. It's not an issue of timing, Your Honor.
All right. Well, I can't tell that from looking at the pleadings.
The complaint itself, Your Honor, it is attached. The
Oh,
notice
there it
date,
is.
yeah,
I need a microscope to read that too.
And then the
Um,
post. Well,
All
I ain't
right,
even
look,
finished.
hold up, Ms. Furlow.
Okay.
Upon information and belief, you and your guest physically assaulted and threw a pregnant woman down the stairs from your home. Additionally, you committed vehicular assault against another resident of the community. Said act was reported to the police, resulting in your fleeing the scene.
Oh my God.
So this may go back to so it's a just cause termination.
that's correct.
And I didn't put my hands on anyone. And the police was out here. They the one that called my phone to tell me she was sitting on my porch, and she's a good friend of mine. And that man, we got this neighbor. It's a lot going on. So
okay. Meg, are you aware of the circumstance here?
Judge, I am aware that Ms. Furlow has applied for our services, and she spoke with our intake attorney, Attorney Libby McCann, which is
Libby.
who she mentioned. Attorney McCann and Attorney Don Roberts review all of our intake cases and to determine whether they should be assigned out to staff attorneys for further review and follow-up. That is where Ms. Furlow's case is at. That Attorney Roberts and Attorney McCann are reviewing her case and determining level of service.
All right, I'm going to continue this.
Can I take it to trial?
Yes, certainly.
Middleton, I have everything you need, and I only reason I'm taking it to trial because I got a lot. I can't do it all here today, but I will come into the courthouse after I take care of
the trial isn't today, but we'll set it for further hearing next Friday.
Okay.
May 2nd.
Okay.
2025 at 2:15.
Can I come in? Because Monday I'm going to take care of my stuff, so I can come in.
Yes.
Okay.
If you're we'll get these warrants taken care of.
Yes, sir. That's all I need to do.
Well, you might be in jail.
I'll
make sure
even
that
if
you're
I
brought
am,
here.
even if I am, I still want to take it to trial. I'm about to get.
I'll bring you here if you're in jail.
Okay.
All right.
Now, Your Honor, are the warrants related to this incident?
They may well be. One of the warrants is an assault. Let me look at it.
That's the one where they said I put my hands on. I got all the proof. It don't matter.
All right.
My mom was there also, so she got the tape
Okay.
recording.
Yeah, because the incident report on this is from February the 6th. And if the arrest warrant was from that time, there was a recommendation for simple assault based on the incident.
I was in front of the police, so I don't see how that was a simple assault when they called me. And I have
just a minute. Let me pull it up here. SYNQUES. Ms. Furlow, how many kids are still with you?
I got all my kids. I had never lost custody.
No, I just thought maybe some of them got old and moved out.
Well, Javea is currently, she just turned 15, and today my twins turned 11. Javea has been at my mom's. My mom do help me with my teenage daughter, but the rest of them, no.
Okay.
I like that. She says she's got all her kids, and then she immediately says that her mom's got the older kids. So this woman's a mess. She keeps talking about she's got all the proofs. Well, they got all the warrants, so seems like it's a good trade. It'd be interesting to see it go to court, though.
To domestic violence. Count 3, assault and battery upon Craig Kloppenstein.
Oh my God.
That's a 93-day misdemeanor. So that was charged by the prosecutor on February 21st.
Okay.
And there has been a warrant for your arrest since February 26th. But apparently Centerville hasn't made much of an effort to serve the warrant.
Yeah, because They know that. Oh my God. You talking about the man that harasses me every day and called me and my kids niggers and monkeys, who came in my driveway when me and my friend Skylar was getting her phone and put the
All right,
camera.
well, don't tell me no more about it till we
Okay,
get
because I
But
got video.
for the park,
I didn't
this
touch her.
is file number 25359 SM.
Okay. I'm not backing down. That's why I report every
All right,
photo.
well, okay, that's fine with me, but send to. I will email you this right now if you give me your email address.
Me, Middleton?
No, not you,
Oh.
Miss Furlow. You'll get it on Monday.
Okay.
Yeah. My email address, Your Honor, is
Yes.
my first letter of my first name, C, and then last name, Grand Maison, GrandMaison, at Swisstack Levine, all one word, .com.
There's the affidavit, and here is the complaint. All right, so Ms. Furlow, I don't want to take away any of your rights. Legal Aid is reviewing the matter. It's not likely we're going to have the trial on May 2nd.
Okay.
If Legal Aid does get involved, we will probably use that day to schedule the actual trial.
Okay.
I'm in receipt of both the complaint and the warrant, Your Honor. I appreciate it.
All right, thank you. That just took a second. Meg, are you guys interested in that also?
I was just thinking it would probably be appropriate to share it with us since the court knows that she's contacted us, but we aren't attorneys of record, so.
Well, you can share it with your screening staff.
I appreciate that, Judge. Thank you.
It is a public record, so it's nothing secret.
Yeah. That's why I didn't say anything.
All right. Let's revisit this next Friday at 2:15. Ms. Furlow, if you're bond, you can come right in here to the courthouse or you can Zoom in.
Okay.
But if you're in custody, I'll make sure that you're brought in by Zoom.
Okay.
All right. Thank you all. We'll address
Thank you,
this further
Middleton.
next Friday afternoon. Thank you.
Thank you.
You know, they make it seem like it's she's going to be in trouble on Monday, but I think we've seen court too many times. People with all these issues that they just seem to skate past, seem to keep getting them. If I don't put on my turn signal, I end up in handcuffs. But these folks can rack up, 5-10 warrants and end up being okay. I don't know. I don't get it. This next one is Judge Christine Simmons in Michigan somewhere, and this lawyer decides to get a little mouthy with her, and it's fun to watch how she deals with him. So let's see where that goes.
Yes. Just a quick clarification on the Chiquita Bernard matter. That matter was actually inadvertently dismissed about a month and a half ago, and that's the one where we had that brief exchange where it was mistakenly dismissed. We put it on record, and then the court ordered a default judgment. I think the clerks accidentally put it back on calendar, and I found out after I was here for a separate matter that they logged it into it too. So they took something that the court on the record said default judgment. We're waiting for a judgment about 3 weeks, 2.5 weeks.
Did you submit a default judgment?
No, and that informs the second issue that I have here. But the reason I have is, long story short, is, and the court knows this, I'm not going to take up all its time, but just very briefly, if a counsel's on a tenancy matter, then any action that's filed has to be e-filed. And
well, couple issues here.
Sure.
You never filed an appearance on it.
Sure.
So when I'm looking for a plaintiff 30 minutes after the case was supposed to be called,
Sure.
and there's no name for it, who am I supposed to? How am I supposed to know who is?
No, I'm with
who's
you.
on there?
No.
So
I'm with you.
I don't know what the clerk's office may or may not have done. I have no idea. All I know is that this was on my docket for today for
Sure.
2 o'clock. The defendant was sitting here. And after 30 minutes, we dismissed the case.
Sure, I know, but that was 3 weeks after the court already ordered a default judgment when I was here on that same case.
I recognize that, but
Right.
when you don't file it 3 weeks ago, you didn't file a default.
Sure, yeah, but not filing a default doesn't invalidate the ability for the court, it doesn't.
If you had filed a default, the case would have been closed.
Sure, but
When that, and we have attorneys that never file their defaults or never file their dismissals and they leave it on me, then I have to go back in there and either set it for another hearing or enter the dismissal. And so this probably, and I don't have the case open, was not an issue of the clerk's office making an error. What they do when the default was supposed to be entered and it does not get entered by the plaintiff, they ask me if I want to just dismiss the case or set it for another hearing. And that's probably why this got reset for another hearing. That was not a mistake. You never filed, the mistake was you never filed the default.
And I can appreciate the court saying that that's something that can happen. When the court says probably more likely than not, the reason that I'm a little bit resistant to that is that while we were here, we've had a pattern within the history of the same case where it was dismissed before wrongfully, accidentally, and inadvertently. And we had back and forth and change. But with all that said, the reason I
Can
didn't
you
file
put the
anything.
case back in here so I can pull it up? What
I
case is
appreciate
it?
it.
This is,
I have the docket in here.
it's Shakita Bogart, 25-00871.
It's a 1L2. And so the reason that I didn't file it is that if I would have filed an appearance, it would have precluded my client from doing all the paperwork. So initially, I was just going to come here limited appearance. I know that's subjective outside the scope of what the court does. I'm just saying.
We know good and well that if attorney is representing, they're supposed to file an appearance.
Sure.
How are we supposed to know who's appearing on behalf of an attorney if you don't file an
Sure,
appearance?
but not knowing who appears is different than a case that should have been on the record.
No one- the issue was you didn't file a default.
No, but that's what I'm saying, Your Honor.
Yeah,
The
the
reason-
issue, I don't see I didn't file a default, Your Honor.
Your Honor, you're talking about something different than I'm trying to.
Had you filed a default, we wouldn't be here today.
Your Honor, and there's clouds in the sky too, but what I'm saying.
No,
is
there's
something
not no clouds in the
completely
sky. Had you filed a default, we would not be here on the docket today.
Your Honor, I could say the same thing over and over, but that's not what I'm saying. I'm saying something completely different. And if the court will hear it out, what I'm saying is before, if we go by, if something shouldn't have happened or would have happened the way they were supposed to, we wouldn't have been here.
Why are we talking then? What?
No, the point
Well,
is.
no, you were supposed to file an appearance, you didn't do it. You were supposed to enter a default, you didn't do it. The case gets reset because it's lingering. It could have just been dismissed then because it's lingering. If you're supposed to file a default and you don't do it, the court either has to dismiss the case or the court sets it for another hearing. The case is set for a hearing today. You want to rely on the idea that you believe that this was erroneously set for a hearing.
Yes.
The error was that you did not file a default. That is the error that
Your
brought us here
Your
today.
Honor, I can appreciate you saying that loudly.
Ah,
but to say
that's
that
the
there's
error.
one- To say that there's one error doesn't mean that there can't.
You
be
can leave
two.
my courtroom.
But
Don't talk about me saying anything loudly. The reason why I gotta say it loudly, because I said it 7 times,
It doesn't.
and you're not- and you want to talk about some hypotheticals that make no sense. I have other people that are waiting for their case to be called timely.
Your Honor, again.
And so you can
if the
remove
court-
yourself from my courtroom, or you can remove this case. This is over. It's been dismissed.
The court's still talking to me while I'm leaving. so-
Bye.
Take care.
All right, that's it for her. And I did remember to turn the mute off, so it makes no sense arguing with a judge like that. It's certainly not going to help them. I think what some of these problems is these people remember when each other were lawyers, and you see it every once in a while in Judge Fleischer's court. Someone remembers when he was a lawyer, and they want to talk to him like that, and they got to understand that they've got to respect that title. They got to respect that judge. I was going to say robe, but that's not the case in Judge Fleischer's court. So. All right, we're going to go to Judge McNally it was a pretty good victim impact statement on it. So, all right, let's see.
To 5B 147185.
We have a victim here today on that one, I believe. Judge, today's name.
Ma'am, come on up here.
It's funny. Allie compliments me saying I'm finally getting the hint of the streaming thing, and I put it on Judge McNally when I got his logo over his face. So, thanks a lot, Allie. You got my confidence up for nothing.
Please, over to that microphone. Yeah, I know, but come on right over to that microphone over there, ma'am. That's a microphone, believe it or not, on the jury box. Looks like a piece of plastic that you'd throw with a Frisbee. What's your name, ma'am?
My name's Siobhan Thomas.
Thank you for coming. Sir, your name. I should have called this earlier. They never got the paper.
Judge, there was a holdup with the paperwork, and the director of the probation department here at the court was considered enough to push this through.
Well, I know, but I haven't
Thomas,
even read
I
the
had to fill
report
out his
yet.
Paperwork twice.
I didn't think we were having a sentencing on this.
Yes, we are ready to proceed.
Well, I gotta read it.
Yes.
They didn't have this in here when I looked at the report.
We understand that.
You did it this morning?
No,
Yes.
sir, I actually did.
Yes, it's done this morning. The report was done this morning. That's why he didn't have it in his file.
But I had already did it though. I
No.
did it on the 11th.
Mr. Thomas, the report.
I did it on the 11th of April.
No.
That's what I'm telling you.
Okay. There's no reason.
Not the
Hang on,
paperwork, the report.
hang on.
I did the report on the 11th.
Listen to me. There's no
Yes, sir.
reason, there's no reason to argue about
Yes,
it.
sir.
I was just asking because when I read the report this morning, they didn't have this pre-sentence report in here.
Yeah.
When I read the file,
Mhm.
and it said, Vic, defendant called probation on April 11 and requested the PSI paperwork be faxed to treatment agency. He's attending due to no transportation and living in a 3/4 house. Paperwork was faxed but never was returned. That's what they wrote.
Yes, sir.
So they must have done all this morning, right?
Yes, sir.
So why are you arguing with the guy? Where are you going?
The prosecutor said she got to be here. She had told me to let her know.
Oh, well, here's what I'm gonna do. I'm not gonna guess on anything. This report was not in here this morning. I'm gonna get off this bench after I take this next case, and I'm gonna read this report,
Okay,
and then you can call the prosecutor.
okay.
Okay? This is Brownstown, so Miss Foley Carter, it's best to go outside down the hallway and tell her I'd like to see her. And if you want to tell her, Judge said to come in at 11 o'clock, I'll be ready to do it then. I'm going to take one more case, take a recess, and then I'll do it right at 11, okay?
Okay, great.
All right, thank you. I need the prosecutor and I need Mr. Baldwin.
All right, I'll get it.
Kevin DeLon Thomas. Two 5B147185. Just wait 1 second, sir.
Yes, sir.
Where's Miss Siobhan Thomas?
She says in the hallway.
What is everybody doing in the hallway? I thought I said it was gonna start at 11. I need the victim and I need the prosecutor.
Prosecutor, I just in her office, Judge. She's not here. She might.
All right. Your appearance, this is 25B147185, Kevin DeLon Thomas. Tell me your name again, sir.
Kevin DeLon Thomas.
Attorney Mike Baldwin from Missouri.
Where's the victim? I told her to be back in here at 11.
For which case matter?
Mrs. Thomas. I never seen so many people wait in the hallway. I don't know why you would go in the hallway. I mean, I love to say this. It's like going to the Tiger game and not entering through the gate, the gates. I don't get it. I don't understand it. I mean, come on. I thought I told everybody I was gonna be in here at 11. Did I not make that clear? Your name, ma'am?
Ron Thomas.
Ms. Foley Carter, your name?
Caitlin Foley Carter, Brownsville Township.
All right. Do I have your names already?
Yes.
He pled guilty to telephone harassment. He was referred for a pre-sentence report. I have one question. The disorderly that he was convicted of in this court, are you in front of Judge Hessen or?
Yes.
Okay.
And on probation.
Yes.
Okay. He's on probation with Hessen.
And was he not sentenced until after this December 13th, 24 date?
I think where you might be going with this is there was an open warrant, correct me if I'm wrong, and then so it wouldn't have even been a bond violation at that point, but if it was anything, it was a bond violation because he had never been sentenced to probation, so there was no bond.
All right.
Then I got sentenced afterwards.
All right. Lisa, try to figure out how long he's going to be on probation from looking at that. Is everything in this report accurate? Are there any material additions, corrections, or deletions?
The only thing I would like to add is that he's now transitioning into an intensive outpatient treatment facility. As the court may recall, when he came in on Zoom, he was in intensive inpatient facility, so he is transitioning into working towards his sobriety, Judge. There are no additional deletions, corrections, or errors. Based upon the totality of all the facts and circumstances, the idea that we have the victim here, I'm going to ask the court to adopt the recommendation of fines and costs and do some community service. Judge, this was an incident, realizing that there is a similar transaction or occurrence regarding the same victim with Hessen. The facts and circumstances as alleged by my client had a little something to do with calling out of the safety and welfare of the child and reported calling instead of calling CPS. So the victim's here to retort, but my understanding is that these phone calls weren't focused at the victim themselves as to ensure the safety and welfare of this child, which he realizes was the inappropriate way upon which he handled it. And I think that's why the recommendation is so light in the circumstances. Also, that I do believe that there is a divorce or was a divorce going on between the two parties here, the victim and the defendant. Obviously, that can sometimes cause some contention. And my understanding is Mr. Thomas is compliant with making sure that he is not making contact with the victim.
Anything you'd like to say?
Yes, sir. We were married for what, like 5 years, maybe almost 6. I was a terrible husband. You know what I'm saying? I'm not denying that. I was violent, I was aggressive, disrespectful. So I filed for divorce. I knew there was no chance of us reconciling anything. I filed for divorce. The divorce was granted October 2023. Within us going through the divorce, we agreed that I wouldn't attempt to get sole or physical custody of my daughter, but she would still allow me to talk to my daughter and see my daughter on our own terms. Well, that hasn't happened. So here we are from 2022. I have not seen my child. You know what I'm saying? So yeah, sometimes I do call Siobhan. I have called Siobhan phone, and I have got frustrated in the past and disrespected her or cussed her out. But this is not that. I called her phone. She heard my voice. She hung the phone. I didn't call her back. Now I pop up with a warrant for this. Bottom line is I wasn't a good man to her, so I don't know if this has something to do with that, but it shouldn't. You know what I'm saying? I don't know if this laying the foundation, because I have been taking her to court, to family court, to try to get some type of parenting time with my child. So I don't know if it's laying the foundation to where now we go back to court and it's, oh, well, he been harassing me. I have no reason to harass her. I filed for divorce, and it's my second time doing it. So it's no reason to harass her. I have not been to her home at all since I moved out of here. So I don't bother her, and I have been disrespectful in the past, but this is not one of those circumstances. You know what I'm saying? I'm trying to get my life together. I have had a problem with drinking in the past. I checked myself in the inpatient. I successfully completed that, and now I'm in intensive outpatient. And this lady right here, she's one of the advocates for me at the place that I'm in.
And also, he's
right here.
He's
Her
also
name's
working
Amy.
on truck driving school. Is that correct?
Yeah, I was, but I can't do it within, because I go to class every morning. I work, and now I have a new job. I work from 10 p.m. to 6 a.m. And then I go to class from 9 a.m. to 2:30 in the afternoon.
Okay.
So I don't really have time to do that.
Okay. Well, Ms. Willie Carter, the victim told me you wanted to come in on this. Can you tell me your name and whatever you'd like to say?
Caitlin Fuller, Carter, in Preston Township. I don't necessarily need to say anything. I mean, I believe that the charges speak for themselves, especially that he's been charged and he was convicted of similar charges down the hall. The reason for this incident was because he pled back in September. He went into warrant status and appeared for sentencing and continued to contact Ms. Thomas. And specifically, he wasn't supposed to contact Ms. Thomas. So that's why this case was issued. I do believe that she wishes to make a statement.
Please.
Okay, so This is the second harassment charge. This is the second time that we've been in court for this very same thing. We have a very extensive history of domestic violence. He's beat me to the point where I was unrecognizable. I pressed charges. I was pregnant with his child. He's attacked me several times. All of this has been heavily documented. I'm sorry, just being here and I'm a little bit overwhelmed. The harassment has not stopped. It is continuous. He was told in court last time, in January 22nd, to not visit any of my social media. He's coming on to.
Did I order that?
No, it was
Judge hasn't did that.
She ordered him not to go on,
Yeah. No,
not to go on her social media.
Right, no contacting status to social media.
he's been on my social media as of April 5th. I'm still receiving private calls. He has threatened me. He threatened to kill me. Sometimes during the abuse, I feared that he was gonna do just that. He prank called the police to my house December the 13th. He told the police that he thought that our daughter was in harm. My daughter now has a fear of the police because she said they're trying to take her. Several officers and cars came to the house. At that time, I had a PPO against him. He still was calling.
You hadn't been served and
He had not been served
Right.
because I do not have an address
Right.
for him. I asked the courts January the 22nd, could he be served at that time? I was told I couldn't do that. I don't know if you have our records before you, but this has been ongoing. I am a survivor. He has beat me. I have marks, permanent damage to my eyes from the abuse that I endured from him. Permanent scars. I think about this every day when I look at myself in the mirror. This has nothing to do with our daughter, the phone calls. I gave the court January the 22nd a recording of him telling me he was gonna kill me. These calls happen all day, all night. 3 a.m. in the morning. He's calling me because he's in the hospital. He's calling me to cuss at me. He's angry that I'm not receiving the calls. All of that here with the prank call that has me feeling powerless. I don't know what it's like to have the freedom. I live in fear. I never know when he's gonna act out on some of the threats that he's giving me, as far as burning my house down, killing me. He's told me, fuck me and our daughter. He's unhinged. As you seen earlier, he was arguing with his counsel. I feel like he's out of control. And in the recording that I had, he threatened me and taunted me and told me that the police aren't gonna do anything because they never have. Again, this is my third time pressing charges on him. This is the second time with this court. Nothing has ever been done.
how long does Judge Hessen have him on probation, Lisa?
She sentenced him on January 22nd to 12 months.
So he's got another 7, 8 months. Let's see.
Your Honor, I think it's important to note that he's turned himself into the intensive inpatient treatment program, and now he's transitioning.
He's done that many times in the past.
Okay.
I've never done that. I've never done that.
All right, wait a second. Mr. Thomas, can I make a little suggestion?
Yes, sir.
I take my humility button
Yes, sir.
from a 0 or 1 to a 10. I don't go for this nonsense.
Yes, sir.
You just got done admitting you were a lousy husband, you beat her.
I was.
And and then she's reiterating this, and you're acting like she's lying or doing other things. I don't like this.
Yes, sir.
I don't think any of us should be assaulted, harassed. You could,
And then if I could say something, Judge, it's impossible. Like, I mean, I'm not saying everything she's saying is a lie. Within our marriage, that did go on. But my thing is this, you're coming to court saying that I was harassing you April 5th. Impossible. I didn't even have, and she will attest to that, I didn't even have access to a cell phone. My cell phone was locked up until April 14th. From March 14th to April 14th.
correct me if I'm wrong. Let's just keep your voice down.
Yes, sir. I'm sorry. I just get excited. But my phone, my cell phone was locked in their possession. You can't access the phone.
Hang on. Did you plead guilty to this?
No, this is something she just said just happened last month.
Hang on a second. I'm talking about this offense.
Yes, I called her phone.
Let me finish.
Oh, I'm sorry.
From December 13 to 24.
Yes, I called her phone.
You pled guilty to this.
Yes, there was no
Then don't come in here and deny guilt if that's what you're trying to do.
No, I'm not. I'm just saying there was no threats.
Your Honor.
I don't want to sound like a tough guy, but I don't appreciate the way you're talking to me now.
I'm sorry.
Okay?
Yes, sir.
You're now acting like you did nothing wrong. Wait a minute. You're now acting like you did something wrong. That was very compelling what you just told me.
Yes, it was.
And I don't believe for 1/2 of 1 millimeter of 1 second that this lady was lying to me.
I don't.
Okay, I'm just telling you, I don't believe it. I can pretty good at reading people. Anybody would be after this many years of having this many people in front of you and this many people lie to you and tell you that it's 98 degrees out right now and we're in Tahiti. I don't know what to tell people. I just think if I were you, I'd back this down. Don't act like it's her fault. I can't see where she's done anything wrong here. If I had to assign blame, it's 100 to 0.
I said that, and I apologize. That's why.
Don't apologize to me.
I'm saying I apologize.
You didn't call and harass me. Listen to me. I don't want you to talk right now. I'm trying to give you some advice. Your record looks like you're one of those guys. You can look at me all you want. I know they date back, but 06, felony unarmed robbery, RNC motor vehicle, and 12, larceny by conversion, 5-year felony on that, and 12, attempted assault, resisting, obstruct an officer, 13, larceny of building, 13. Now, to your credit, it does seem as though you stayed out of trouble. I mean, you had a couple warrants for your arrest that you should have taken care of, but still in 24 disorderly. And now you seem to be losing it. I think you want to control her. You don't get to control this lady. She's not your wife, and even if she was, you don't get to control her. Now, I got to tell you, I've come out here from thinking probably probation to probably jail right now. So if I were you, I would go way down with my anger level. I don't know if you were permitted to finish. Did I permit you to finish, ma'am?
I was not finished.
Go ahead.
I want to say that I don't even know if this matters, but I am not his first victim. I am the only person that follows through. And even though I said that there's been multiple cases, Taylor put these multiple police reports that were made with domestic violence, where it still doesn't speak to the abuse that I endured. I've seen things I shouldn't have seen. I felt things that I felt. He has changed me on a very chemical level.
On the what?
The chemical imbalance. He's changed me completely. my way of thinking. I'm afraid. I no longer enjoy like anything. I don't sit on the porch when my daughter watch her play anymore. I don't know when he might drive by. I've seen him drive in my area last year. It has been, he's made police reports against me. The harassment has not stopped. I do not feel safe. I'm always on high alert. Again, he has totally changed me from the person that I used to be.
Well, did I let you finish now?
Yes.
I'm gonna encourage you not to let anybody change you. We control our own emotions, destiny. Look, don't do that to yourself. Wait. Now, I want you to know, I have records in front of me. I have a domestic violence that was filed and dismissed. I don't have any domestic violence conviction, although he pretty much just admitted that he used to engage in acts like that.
The city of Taylor.
The city of Taylor, it was dismissed. Let me just double check that, but I'm sure I saw dismissed. No, that was in Inkster. It was dismissed.
That's not me.
Pardon?
The Inkster case probably wasn't me.
That was in 23. I don't see anything from the 23rd District Court in Taylor on his record, either as a charge or as a conviction. So, all right.
If I can, I don't want to talk directly to her, but I apologize. I know I was a terrible person. You know what I'm saying? I had an issue with drinking. Like, I turned into a different person. That's why I'm finally trying to get myself together. I I went and enrolled myself in inpatient. I successfully completed inpatient on the 14th, and I didn't want to go straight back to the community because I didn't feel I would be strong enough to not drink, and I don't like how I make people feel. So I asked, can I go into the second step? So now I'm living in intensive outpatient through community lighthouse in Plymouth, Michigan. And like I said, I'm in class. I live with them. Like, I live in an apartment. They take me from my apartment to class, back to my apartment. I work from 10 p.m. to 6 a.m. and that's Monday through Friday. I just feel bad for me damaging her as a person. That's not my intention, and nor did I do a prank call. I did call and ask them to do a welfare check, and I admit that was not no prank call. I did call it, and I gave them my phone number for them to call me back.
What does the order of the circuit judge say on the divorce?
And that was the thing. It was no order with my child. It was what it was.
You got a divorce, right?
Yeah, I divorced.
The order probably says you get no custody and no visitation.
No, right. It's reserved. Because
So as of right now, you have no visitation rights and no custodial rights,
correct,
right?
Correct.
Okay. So you need to understand something. This is our justice system.
Yes, sir.
Judges speak through orders.
Yes, sir.
Judges speak through orders. You don't get to start circumventing judges' orders. And that's really what you're trying to do when you're talking about wellness checks and all these things. If you have any evidence that she's abusing that child, then you should contact CPS. But you don't have the right to circumvent a judge's order. This is getting worse for you the longer we're going on. I'm just telling you.
Okay, I'm sorry.
No, you don't have to apologize to me that your true colors are coming out. I mean, you don't seem to be remorseful. You started out that way.
I know. I feel bad.
All right, listen. But
I do, Your Honor. I haven't had the opportunity to apologize to you.
All right. Well, you're not going to have the opportunity today either. I'm ready to make my ruling. If somebody wants to say something, they can. I'll shut up. I'll listen. If they don't, then I'm a sentencing. Anything else?
Very briefly, Judge. The child support is in reserve, so what my client can do is exercise his rights and get parenting time order or something, so that is reserved and he can move forward.
It's up to him.
In the future. Yes.
But he's not gonna contact this lady.
Right, exactly. So it's still available to him if he wants to pursue that.
I did not, anything else? Anything else, real briefly?
It's not a matter of him not knowing that everything was on reserve, because as he said, he's filed multiple cases against me in court, and they're dismissed. I have sole physical custody and sole legal custody of our daughter. He's harassing me 3 a.m, threatening to kill me, burn my house down. I have a property in Detroit that's unkept because he used to tell me, Detroit doesn't have the police. I'll kill you when you go to check on your grandma's house. So, yeah, I paid my grandma neighbors to help me.
18 months probation. You cannot leave the state without the consent of the court or violate a law. To change your address, place of employment, home telephone number, you must notify probation. The act to report is directed. No contact with the victim at all. If I find out that you've had contact with her once, sir, I'm going to give you 90 days.
Yes, sir. Can I ask one question, please?
I'm not even done
Oh, I'm
yet.
sorry.
No contact with the victim. You cannot write, phone, see, text, email, or communicate with her in any way. You're not to possess any firearms, and you're not to possess any dangerous weapons. No firearms, no dangerous weapons. I don't expect to see you anywhere near this lady. I don't expect you to call this lady. I don't expect you to have John Smith, have Jane Doe, have Ivan Bukanovich, have Harold Sobolski call this lady. Nobody is calling this lady for you or on your behalf.
Yes, sir.
Do you understand?
Yes, sir.
Judge, realizing.
I'm not done yet.
Okay.
Why does everyone want to keep interrupting me? 15 days jail, I'll let you do 5 of those on the court work program. There's a $35 a day charge for that for a total of $175. You're in custody for the next 10 days. Stop, don't interrupt me. Yeah, don't interrupt me.
Sorry.
$100 fines, $100 costs, 75 victims' rights, $50 justice assessment, 3 1/4. Screening fee is $60 for 425. Attorney fees are $40 for 465. Probation fees are $360 for 825. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer. For purposes of appeal, you need to get your life under control. You need to stop being obsessed with this woman. You need to stay away from this woman. You need to not call this woman. Do we understand one another?
Yes, sir. Can I please ask you one thing, sir? Please.
Hold on, Judge,
He's not reporting later.
No, well,
He's not reporting later.
Can I just put it on the record?
Yeah, you can put it on the
I'm
record. Of course you
asking
can
the
put it
court
on
to
the
allow him to finish his intensive outpatient treatment and turn himself.
record. He's gonna go now. Have a seat.
Yes, sir. Come on.
Probation will set up terms of payment with you.
All right. So, how many people think by the time the judge wrote the order, he had already violated it? When you have to, when you call the police to do checkups on your girl because she won't answer your calls, you know things are going just too dang far. So, makes it all fun. We're going to jump to another Judge Middleton clip because I like Judge Middleton, and it's Saturday. So here we go.
This is New Res LLC versus Jared Michael Benek on Electric Court in Sturgis. Attorney Mirella Albu is here from the Trott & Trott Law Firm in Detroit on behalf of New Res LLC. This property was sold at a foreclosure action last August 22nd. And this probably has been in the works for several years. You have 180 days to vacate, or they can bring this action. They've waited well beyond that. And at this point, it's the bank or this New Res intentions to take possession of this property and probably sell it. What's your position, Mr. Benek?
Okay, the only position I really have is we started out, my son, I'm the father, and we started out with a payment plan with them at 3-point-something% rate interest. And they never told us anything. After about 2 years, it started going up and he got behind. It was like a taxi kid is kicked out. We couldn't pay. There's no way he could pay and keep up. And on top of it, he lost his job and he tried to fix all that too. So we went through a
So
lot
are
of
you a co-signer for your son?
I'm just speaking for his behalf because and I'm really tired. I take care of most of the stuff in his house. He's like almost sleeping here in the chair. I can show you if you want to see him.
Well, all right, just a minute. What's your name?
Michael Benek. I'm his father. I've talked to them before. And
Just a minute. Mr. Benek, do you have a law degree?
No, I do not. I don't have to have a degree to stand to freedom of speech.
Waking up.
So,
I don't need to talk to him. I need to talk to him.
Well, he would like to have a statement. I guess I can't speak in his behalf.
No, you can't. You need to have a law license to represent somebody in a legal action.
Well, I guess I'll have to go to court then, won't we? All I'm doing is just trying to tell him we're not fighting over the house.
All right,
we already have it signed. We don't care
let me
what happens.
talk about where we are here.
Okay.
Your son had a variable rate mortgage and his rent went up, or his payment went up, and he wasn't able to make it.
They doubled it.
This is my turn to talk. This is my turn to talk. So he hadn't made the payment probably in several years. Probably it wasn't made at all in 2024 and probably part of 2023. The house was foreclosed on last August. So this didn't sneak up and bite you in the ankle.
No, we
this
didn't.
property.
But we didn't get any. We couldn't talk to him, sir.
You got a notice from the sheriff that your house has been foreclosed on. So they can't do it unless you get notice. They post it on there. So you've lived there at least since August, September, October, November, December, January, February, March, April, and soon to be May, without making any payment. So your son has the benefit of free housing. So I want to talk to him, or I'm going to default him. Sitting there sleeping in a chair. Wake up, dude. You're about to get kicked out of your house. Are you Jared Michael Benek?
Yes.
All right. The mortgage company wants your house back. And they have asked you to move. Have you made any provision to move?
I've been having a hard time getting money to move.
Yes, well, you've lived there for free for 2 years. So theoretically, no one does. You should have a big pile of money when you didn't make your house payment to move somewhere else. But this proceeding is an unpleasant one. It is what property owners and landlords do to get their tenant out. The tenant would never move otherwise. You've known since last August that they want you to move. We're now almost in May. So I have to continue this matter. I'm going to continue it to May 2nd at 3 o'clock. Does that work for you, Ms. Albu?
Yes, Your Honor.
All right. Now, this is the end of a long process. They had a sheriff's sale last August. And you had 180 days to redeem the property. March, which would have been March. And now you haven't redeemed it, so they're asking you to move out. They want to take possession of the premises. So if they get what they asked for on May 2nd, I would order that you be out of the house by May 12th, which is 17 days from now.
Yeah.
All right, so we'll talk about this further. Now, I read the advice of rights, but you were sitting there in a chair. I don't know whether you were paying attention or not, but what I did say is you have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. So I sent you the information with legal aid's name and number on it. You could contact them. But I don't really know that you have a defense. You haven't made your payment. The bank foreclosed on it. 180 days passed and you didn't redeem it. And now they want the property back. And so it's a tough situation. We do this every Monday and Friday. And people are struggling. But have you made any effort to find a place to move to?
What do you ask?
Any effort to find a place?
No, we just started because we didn't get informed that they sold the house. I'm trying to tell you, there was no communication between these people. They came to our door and wanted to give us a paper to go to court here. It's the only time we ever spoke with them. But I mean, he doesn't know what to say. He's a young guy. I was helping him get the house. I use even my own money. I'm going to die soon, so I don't care. But all we're trying to do is just leave the house, give us 30 days or a little bit more, and we'll move. My daughter was buying the house.
We can talk about that next week. Sergeant Bruce Morse posted this on your door. It was published in the, I think, Three Rivers Commercial back in June of 2024 that the sheriff's sale would be in August. They posted it on your door. You didn't show up at the sheriff's sale. It was actually adjourned from July 11th to August 22nd. So they did post it on your door. And then you got notice with this when they served the notice to quit on you several months ago. But you do know you haven't made any payment on the house probably in 2 years. So they're foreclosing on that. So we'll talk about that. You may ask for 30 days or something, and they may be willing to grant that. Ms. Abu can check with her client and see what consideration they can give. But I would suggest you start making plans to move. The date would be May 12th. If the plaintiff agrees, they could give you more time than that. So we will do this again next Friday at 3 o'clock.
What happened to Abby in the picture? Goodbye now. Whatever.
Do you want to ask for more? What did you ask? Another question?
No, we just thought that since my daughter took over the contract and he's buying it, that it would clear his record and wouldn't have to mess with this at all because she's buying it.
I don't know about that. So your daughter's buying the property from Shell Point?
Told me she already has agreement and stuff and that she's buying it. I can get her out of here next time you want, but.
Well, they haven't got possession of it yet.
He said,
what's your daughter's
you guys move, you got to move, but she wants us out in a few months anyway, so we were trying to do that. That's what we started working on.
What's your daughter's name?
Abigail Butts. I think she's still got her original last married name. She hasn't got rid of that yet.
And she is purchasing it from who?
She says she's got the bank approved through some bank to buy it, and it was already approved that she was buying it. She's moving.
All right,
she
well,
said
let's talk about that.
Here, and I took care of her kids for 3 months and didn't get paid a dime. I'm trying to help.
They can't sell it until they take possession of it. They don't have the authority to sell it right now. So she may have a bank ready to loan her money to purchase it, but it isn't for sale yet.
So we waited that long because we thought she was doing something through there. Oh my God.
Okay.
Okay. Well, I guess
we'll talk about this.
What we're going to do is just try to move as soon as we can. I don't care what's going on. This is all a bunch of crooked shit. We're just going to get out of it. We're going to move. And if you don't get his record straight.
Sir, I don't want you to curse on the record. And it isn't
Oh,
crooked. Your
did I
son didn't
correct?
make the payments.
Oh, I
They
said
gave him
shit.
notice.
Oh.
You've been living there free for 2 years and
Okay,
somehow the
okay,
banks are
but
crooked.
we were trying to move. We're trying
We'll
to
be
do the
back
thing.
next
You know what
week
Tommy's
at
like.
3 o'clock. You can rant at each other there in the apartment and I'll see you next week.
All right. Thank you,
There
Your
may
Honor.
be some crooked stuff going on, but I don't think it's the bank. All right, Ms. Abu, thank you. I did most of the talking and you just had to sit here and listen to me, but we'll see what we can do next week. And if you check with your client, they can give them some additional time to vacate.
Yes, Your Honor.
All right, thanks a lot.
Thank you.
All right, so that attorney lady had the easiest job for that hour. I think the funniest part about having Linus in the chat is to use words that she has to go look up. I think what she just needs to understand is I have to go look up words in the English language trying to figure out what in the world people are saying, but we get to do that. Here we got one with Judge Rossi. He's always got some interesting ones. Let's go there.
And this matter comes before the court today on Mr. Beeson's request to withdraw his counsel in this matter. That is also supported by a certified or a notarized letter I received from Miss McKaylee requesting new counsel due to a breakdown in the relationship. I would invite counsel, will you please place your appearances on the record at this time?
Tiffany Burks on behalf of the people.
And Mr. Beeson, you're muted.
Sorry. John Beeson, Your Honor.
Thank you, Mr. Beeson. Anything to add to the motion, Mr. Beeson?
No, Your Honor. Ms. McCauley is present, but she has her audio on.
Yes, no, that's fine. Any position from the people on the motion to withdraw as counsel?
No, Your Honor.
All right. Well, in that case, I will grant the motion to withdraw because Ms. McKaylee has indicated a breakdown in the relationship. And Ms. McKaylee, is it your intention at this point to request appointed counsel, or are you going to hire new counsel on your own?
This is a motion for me to get off probation, right?
I think there also is a motion to terminate probation in here. You know what? Let me handle the counsel one first so we can determine whether you're supposed to speak on your own behalf for probation. I had two motions, Mr. Beeson's motion to withdraw, and then also, yes, you're correct. Your next one up is yours to get from probation. So, what's your intention going forward with regard to an attorney?
I do not
to
wish to
represent?
have Mr. Beeson represent me, Your Honor. I made it clear to Mr. Beeson that I did not wish to sign a waiver, and he manipulated me into signing the waiver, did not give me a copy, and I had to obtain a copy of that waiver, which is why my case was bonded over. It has also been on my record that I have absconded for 2 years, and I've never ran. This is a major problem. It has stopped me from being able to better myself, Your Honor. I am very frustrated. I don't owe you guys anything. I don't owe you guys any community service, any money, and I am still being punished.
All
Your
right.
Honor, may I address that real quickly? Just so
Yeah,
there's
you
a
may,
clear
Mr.
record.
Beeson.
The record is, I have nothing to do with her previous, whether or not she has a notice on her file about fleeing. That was my concern. Secondly, Judge found over Miss Cawley from the prelim. She signed a circuit court waiver. Her case is already bound over. And I explained to her that by signing the document, she did not have to attend in person for the plea not guilty from the circuit court judge. So I don't know if she understood that or not, but you can clearly see there's a breakdown. So I ask the court to grant my motion.
Yep, no, I can see the breakdown in the relationship. I will grant the motion and allow your withdrawal at this time, Mr. Beeson. And I'll ask you, Ms. McKaylee, is it your intention to hire a new attorney, or would you like me to appoint an attorney or have the defender's office assign an attorney to represent you at this time at no charge?
No, I would like to get this motion going. I don't need an attorney. I'm not.
Yeah, I'll continue with your motion today. I'm just thinking going forward. And is this the only thing you're in front of me on, or is there? Because review of the case indicates there might be another case coming here.
Yeah, May 13th, the driving while intoxicated was bonded over for May 13th in front of you. Also,
Okay.
the
Who's
reckless
representing you on
driving,
that one, Miss McKaylee?
I am currently looking for someone to represent me. I have a lot of support. I am in the FIT program, and we are looking for an attorney to represent me in this situation. Also, to take care of that absconding that was on my record. That has really put me in a bad situation.
Okay. All right. Well, what I have here is I extended, let's see, probation here for 90 days because of that OWI that was pending in 61st and has now been bound over and will be in front of me in May. And I amended the discharge date from probation to August 23rd of this year based on that. And, based on the additional charge for OWI, I don't see any alternative here but to keep you on probation for that time. Are you still wearing the scram, Miss McKaylee?
I am, Your Honor, and I have been wearing it since November. I have no problem with wearing the scram. I am in cosmetology school because I tried to take CNA and I was denied because I was listed as absconded too for 2 years, which
Yeah,
makes
no,
my
I
guidelines
do.
go up, which is a major problem and it's not being acknowledged. So I need
You-
an attorney behind all of this stuff that's going on. The amended sentence was not represented to me. When it was represented to me, it was represented to me first without a signature by you. It's just been, I haven't got anything in the mail. Um, it's
Do
been a
we do
lot.
we have
I
a
have,
good mailing address for you, Miss McKaylee?
yes, you guys have.
Okay, yep, that is what we show in the court record here. So that is good. We're at least sending stuff to the right location. What I will do, well, in the meantime, prior to that conference, and Mr. Beeson has represented you on that case up until this point. Now you don't have an attorney. What I will do is direct you to obtain an attorney within the next 2 weeks. Because we determined that conference you said is coming up on May the 13th. Yeah, so that's gosh, 2 weeks is just going to put you a week before that. If you don't have an attorney prior to that date, what I will do is I will appoint a court-appointed attorney to represent you, so you have representation at that hearing. So today's order, though I'm going to keep you on probation, it will direct you to obtain counsel on the new case of your choice within 2 weeks, which would make it by let's see here, May the 7th, or I'll appoint counsel.
Your Honor, this case has been pushed out and it is hindering me. You guys extended my probation past my max date.
Nope,
You did not
I did,
extend
but
it for
given the
30 for 90 for 60 days. You did it for 6 months.
Yep, well,
Um,
and given the circumstances, when I have because I do have you on probation for OWI, and if that ever happens and I get someone else that picks up another OWI charge, I keep them. I'm not treating you differently than I treat anyone else. I do keep folks on probation, and it's mainly because I want to be able to monitor whether you're drinking and driving during the probationary period. If you were, then I would take the additional step of holding you in jail. You're not indicating any of those problems, and the scram, as far as I know, has been good for you. So I mean that you've been compliant with the scram conditions, which is a good thing. That gives me the assurance that the public's safe while you're out there while we get the new case worked out. So that's all information I can give you.
Judge Rossi, you also told me that you were going to release me from probation back in September, and that did not happen. Like, I am getting the runaround with you guys, and I do not feel like this has been fair. I am not disrespectful, so I'm not going to question your authority during court. If you tell me something that you're going to do, that's what I expect. That was supposed to be done before this event even occurred. The reckless driving was thrown out, so I don't even know why you guys would be coming at me for a DUI.
Okay, yeah, well, the indicator I have here is that it's a reckless and an OWI in the 61st District Court. Is that what you, or did you just get bound over on the reckless?
I didn't get bonded. The reckless was dismissed
I
with
see. Oh, but I still
prejudice.
have the OWI coming in front.
Right.
Yeah, no, and that's the more serious thing, and that's what's going to require, to be addressed by your lawyer.
Your Honor, I wasn't driving, so this is just hindering my life.
No, I get it. And I understand that pending charges and the absconding charge and all of those things have a serious impact on your life. And my flip side of it is, I do apologize. I know it can feel like the system kind of pushes and moves you around without much regard to what's really happening out there. However, I can tell you, from my perspective, particularly with OWI cases, I am in favor of resolving them. However, I've got to look at the, unique situation of the concern about public safety when I've got someone with OWI charges, because, as you know, if you got behind the wheel drinking or having used something, as I describe it, it's like shooting a gun into a crowd. It could, you might not hurt anyone, but then again, you might kill someone, and it's just too much of a chance for me as a judge to take. So I've got to be extra cautious with OWI charges, and I always am. Just for the public safety aspect. So that's the best explanation I can give you at the moment. However, once we get an attorney and we get that status conference, we can address those things in front of me. I can advise you, if you plead guilty on another OWI charge, the likelihood is that you'll remain on probation for an additional 3 years. That's my policy, at least on every OWI third charge that comes in front of me. So just so you're, got some parameters to think about going forward. And like I say, if you're successful hiring a new attorney, have that attorney file an appearance. If I don't see an appearance by a week before that status conference, I'll send it over to the county and have an attorney appointed.
If I'm not able to get counsel, I don't wish for nobody from the courts to represent me, Your Honor. I have no faith in you guys.
No, well, and all I can tell you is those offices are independent, the defender's office and our court-appointed counsel list. Other than the fact that I'm paid by the state of Michigan, but my staff and the rest of the court's paid for by the county, and the defender system is also paid by the state of Michigan and the county. However, we don't have any control. They should be an independent advocate for you. In other words, they don't work for me. They're there to represent you in the system. So, and I can tell you, you'll be much better off going forward with an attorney than going forward on your own, because the attorneys do.
You guys don't have me driving. This case is pointless. It's just holding up my life. That's all it's doing.
Yeah, no, and that is very much the effect of this type of
You
charge.
guys extended my probation past my max date, and I don't owe you guys anything. I've done all my community service.
No, the number one concern here is the new charge. At this point, Ms. McCallion, we'll deal with that when I see you in May.
So the reckless driving, if they dismiss that, I don't understand why they're still pushing for the DUI.
Yep, that's a question for the prosecutor and for your attorney to discuss, either prior to that conference or at that conference. So like I say, if you're successful hiring an attorney, have them file an appearance, and they can get talking to the prosecutor's office. If not, I'll get someone appointed. The faster that happens, obviously, whether you hire an attorney or I appoint an attorney, the more communication they can have in advance of that conference to address your concerns.
So, okay, can you tell me about why you told me you're going to let me off probation and did not do it?
Well, I can't tell you exactly, because I unfortunately don't remember every single thing I say when I'm
but it should be on record, Your Honor. It should be on record. We did that
no,
before.
and
I lost my job behind being on scram again, like I told you it was going to happen. And I lost my job, and I was like, okay, that's fine. I got some health issues going on, and I'm going to be off probation, so I can just sit down and go to school. I could not do that because of the absconding.
Yeah. Well, and I know why I
when
put you on the scram was because, the
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 violation,
violation, right? That I can tell you. But I can't say, yeah, and I can't
but you
say
didn't
that
take me off
obviously.
probation like you told me you would. You said if you do scram with no hiccups, I'm going to take you off. That did not happen.
And I had you on Scram starting on March 8th, and you've been on now for, what are we at here?
March
We're not,
8th. No. Your Honor, you put me
oh,
on.
that's March 8th. Oh, I see. Yeah, when did we put the Scram on? You said
I've been on
November.
Scram this time since November. Before I got off Scram in September and I was supposed to be let off of probation. That was what you told me in court. I told you I work at a medical factory and that I believe I will be let go because of this Scram because it's a very conservative place. I was let go.
Yep.
When it came
No.
time for me to get off of Scram off Scram, I was told by Shannick that I'm not eligible to be let off of probation, which I don't understand why you would even tell me that.
Yep.
That
No,
feels as though it was to mislead me, so I would accept the scram. I did, which I've been on scram 4 or 5 times. I've never dropped dirty on scram.
yeah, no,
Never. I am
that's,
not being acknowledged for none of this time or none of this work that I'm putting in. My life is only being held up.
yeah, and I see what you're saying here because
I
you
put
started
myself
that
in treatment.
probation, looks like on February 23rd, 22. Well, and the other explanation as to why I would have
22.
not let you off. Yeah, well, that's when this case started, right? When I put you on probation in the first place. Would have been February
This case is
22.
from 2020. Actually, 2019 is when the case was
Yeah,
when
though
I
we
first.
probably entered the order, the plea resolving the case could have been 2022. Uh,
Okay,
yeah.
so what do I do about, I don't want to be disrespectful, but like, what do I do about you telling me one thing and that not happening?
Well, the only safe way, as I tell people in anything, is to have me reduce it to an order. There are two ways that can happen. I can do it on the record in court, and your attorney can obtain transcripts of what I say in court, and I do honor that. If I say it on the record in court, then I do follow what I said. And then second is, I do a written order. Sometimes your attorney will generate a written order for me to sign, and then we have it in the record. So then when I make a representation like that, and that again assumes nothing changed. And I look here and I say, well, what changed? And of course, the biggest change was you picked up that additional OWI.
That was 2 months after I was supposed to be already off.
Yeah, and I'm
And
looking at
it's not, I
this.
wasn't even driving. So it's just me being at a scene. You got my name coming up, and now because
Yep.
I have a history of DUI is really why I feel like you guys are coming after me. But that's personal feelings. And
Yeah,
I'm
well,
not
and I
gonna
don't make the charge decision, that's entirely the prosecutor's office, and then it gets in front of me, and they'll give you an evaluation based on the facts of the case. It doesn't, just because you're charged with it does not mean, of course, that you'll ultimately be convicted of it. But while it is a pending charge, and because of the prior OWI, I need to be cautious and extend the
but
probationary.
why didn't you follow your order of taking me off probation?
Well, I think the number one reason that I can give you on that was picking up that.
I didn't have a case when it
I
came
see.
time for
Right.
me
What
to get off
and
probation.
your probation would have ended with the scram, is what you're saying. Well, and it's right
In
about
September.
right about the same time because I put you on scram
No.
November. You'd have been on there for at least a couple of months till January,
Well,
and then
I'm talking about September of 2024. I was supposed to be off of probation, off of scram, done. That was the agreement you told me in court. You said, I feel like it's necessary for you to do scram. I told you then I have done scram. I think then it was like 3 times. And I've
yep,
never had no issue with scram. You said, well, you do scram this time and you have no hiccups. I am going to let you off probation. That did not happen. That was the first week of September when I questioned William Shannick about it because I was transferred back to him from Dominic Milton. He said, I remember the judge saying that in court, and he told me he was going to look into it. And then he said, oh, you're not eligible to be let off of probation early. So That's where my frustration come in at.
Yeah,
And
I
then
would
this case
understand it,
being
and
totally BS, and it's like really holding on my life and stopping me from being able to better myself.
no, I get it, and all those are valid considerations. However, you know, the only thing I can posit there is that what got in the middle of this is we were coming close to the time when you would have been eligible because of the expiration of the 3 years of I put everyone that's an OWI third on 3 years of probation. Sometimes I let people off 90 days early from probation when they have a good record, and that's what would have happened had you
It didn't happen, is what I'm telling you. It didn't happen. This case is 2 months after I was supposed to be off of probation. You did not let me off.
Yeah, no, and the only thing I can tell you is what happened there is you picked up that
Your Honor, I picked it up 2 months after you told me you were supposed to let me off probation.
well, that was contingent on nothing else happening, and when you
I
pick
was
up a new
supposed to be
charge,
off, Your Honor. You keep saying it's because of this new case.
yeah,
I was supposed to be
no,
off September. This case was caught at the end of October.
yeah,
But
I
like I
get
said,
it.
I wasn't driving. I went and hired an attorney. He did not do what I told him to do.
Well, and I don't have
I'm
any
really
facts
feeling like
about
I
that
need to
new
get
case.
other people involved because this is ridiculous. You guys have
Well,
had me as absconded for 2 years. 2 years. I've been to jail. I've been in front of you. How is it possible?
yep, and I'd
I
have
am pissed.
to.
I'm not even gonna lie because I am trying to be better. I am trying to better myself to be a good example for my children, to make my life more financially stable, and you guys are hindering me.
Well, and that I can certainly see how you'd have the feeling. However, I got to deal with the new charge that's in front of me, and that's what's gonna, you know, kind of set the course.
Well, I
for the
have to
next
go in
3
front of
years.
you. I don't see why you're keeping me, why you're denying my motion to be off probation. I
Yep,
have to go in
no,
front of you. You guys dismissed the reckless driving, so I don't know how you're going to get me with a driving period because I wasn't driving. I was
well,
with
you're
a
gonna have
licensed
to.
driver, wasn't in the car or nothing.
I can't weigh in on that because I don't know any of the facts of the new case, but you're gonna have to address that with your new attorney.
Okay,
Good luck to you, Miss McKaylee.
sure.
All right, so my thoughts about this. Judge Rossi is a saint. I don't know why in the world he was so patient with her, but that's why he's a judge and I'm not. It was amazing how patient he was with her. I don't understand why people continue to get free attorneys. I get the right to an attorney, but at some point, you know, when people, you know, are building up 5, 6, 7, 8 cases, at what point, you know, do we just start holding people accountable for something? I see people getting multiple OR bonds, and none of that makes sense to me. So I'll back out of that one. It is getting to be 9:23. I'm an old man. I gotta go to bed. I got a lot of stuff going on. Thank you so much for coming out. We will do another live tomorrow. And then we'll be back on Monday with Judge Fleischer just as soon as Linus gets me the pictures for the thumbnails. So you guys have a great weekend, but we will see you again tomorrow.